A Louisiana educator is now at the center of a shocking scandal, facing more than 300 criminal charges. He's accused of allegedly soliciting and even paying his own students for explicit photos, including close-ups of their feet. He was arrested, and now he's learning a lesson in law. I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Before we get into this case, I want to tell you about something exciting at Law and Crime. We are launching a new channel called Scandal that is dedicated to exposing the dark side of fame, covering all the wild crimes in Hollywood and diving into the disturbing rumors floating around celebrity circles. To stay up to date on all the latest celebrity scandals, click in the link in the description of this video and subscribe to Scandal today. All right, back to the story. Class is not in session for one Louisiana educator. Jarvis Harris went from being a speech therapist at a Mandeville-area high school to being locked up behind bars. According to the St. Tammany Parish Sheriff's Office, they began investigating Harris in October of 2024. When deputies received a tip alleging Harris had been paying students for pictures of their feet. NOLA.com reports a student alerted an administrator at the school and authorities were brought in. Harris was placed on leave and detectives launched an investigation. What they uncovered, we must warn you, is disturbing. They combed through hundreds of documents from social media accounts, obtained phone records, conducted interviews, reportedly revealing that not only was Harris allegedly paying students for feet pictures, but he had also obtained other sexually explicit videos and pictures of students, leading to more than 300 criminal charges against him. Warrants were issued for Harris' arrest, and he was located in a neighboring parish. He was taken into custody and booked as a fugitive. The charges include 1 count of indecent behavior with juveniles, 142 counts of pornography involving juveniles, 60 counts of computer-aided solicitation of a minor, and 102 counts of prohibited sexual conduct between an educator and a student. At this time, it's unknown how long these alleged crimes have been taking place. Other details, such as how much he was allegedly paying students, how many students participated, and if there were any other teachers involved, is also not known. Authorities say some of the students have been identified, and detectives are still working to identify others. And joining me today is legal expert Joe Tamburino. Joe, thank you so much for being here today. Let's just jump right in. With more than 300 charges against the suspect, what does this case say about the severity of the crimes?
Hi, Kennedy. Thank you for having me on. Well, it says that they're pretty severe, and it's very unusual to have all these types of charges. You see, most of the time, even when the police or a prosecutor has hundreds or thousands of images that have, depictions of child pornography or child abuse, you don't charge every single one of them. But in this case, it seems that the prosecutor decided to do a charge for every image. Is it legal? Yes, it's legal, but it's unusual.
How do prosecutors typically approach a case with this many charges? I know you said it's a little unusual. Will they try to, for him to be getting charged, 300 charges, but will they try to convict on all counts or focus on a few key ones?
Well, they better try to convict on all counts because they issued all of the counts. I mean, if you're a prosecutor, and I was one over 30 years ago, you don't issue a charge unless you want to prove the person guilty. I mean, I think it would be bad practice to charge someone even say with, 100 different counts and you say as a prosecutor, well, I'm only going to try to convict him of 10. No, a professional prosecutor, if you charge 300 counts, you better be ready to prove 300 counts. I would imagine the reason why that they did that is to try to aggravate this person's sentence. You see, the more convictions you have, logically and legally, the greater sentence you're going to get.
Thanks to Morgan & Morgan for sponsoring today's Law and Crime YouTube takeover. Morgan & Morgan is a firm with over 1,000 attorneys because they win a lot. In the past few months, Morgan & Morgan secured a $9.3 million verdict for a car crash in Florida, a $5.6 million verdict for another car accident victim in Atlanta, not to mention $1.8 million in Kentucky after insurance offered them a mere $5,000 in that case. Even if you think your case isn't worth millions, why not start a claim and fight for what you deserve? You can start a claim from your phone in just 8 clicks. So if you're hurt, visit forthepeople.com/YouTube takeover, click the link below, or scan the QR code on your screen. But logically, when you hear about 300 charges, do you ever hear of a person, and I know each case varies, each case is different, but do you ever hear of a person getting charged for every single one of the hundreds that they were accused of?
No, I've been doing this for 36 years. And, it really wasn't until I would say around 2000, 2001 that we started seeing this proliferation of, child pornography or images through computer images, that is, of child abuse and, sexual activities with children. And, I've rarely seen it where there's more than just a couple dozen of counts. So this is an outlier in cases.
Now, the charges include prohibited sexual conduct between an educator and a student. Can you break that down? Like, what does that legally entail?
Yes. Well, you see, in every state, there are laws about that governs things along the lines of people who are prohibited from having any type of sexual relations with another person. The best example is something like, say, a doctor or a therapist with the patient. That's illegal in most states. And of course, an educator, whether that be in high school, middle school, grammar school, and one of the students. So these are very typical laws. I believe every state has them. And it just says that, look, when you're in a certain position, you as the adult or the defendant in a case, you can have relations with certain people, such as your patient, or, if you are, say, a minister, your parishioner. And of course, if you're a teacher, your student.
Now, some of these charges involve computer-aided solicitation of a minor. How does the use of technology impact sentencing in cases like this one?
Greatly impacts them. We see this all the time in federal court, where you will get an enhanced sentence, meaning a greater sentence, more time in prison, say, because you used computer systems, because you use, say, certain technologies, whether it's, by way of texting or doing, using images through chat groups, shared files, things along those lines. So in most states and in the federal system, you will have a greater penalty if such systems are used.
Is there a reason behind that?
Yes, because when you deal with the internet and computer systems, you're dealing with something that, boom, at the blink of an eye can transmit information and large amounts of information, and it will spread everywhere. So what does it do? Well, what it does is it re-victimizes the victim every time somebody sees that image. So for instance, if you have, say, one person, Jane Doe, who's a juvenile, and there's a sexually explicit picture of her, and it goes on some file sharing. Well, instead of just one person seeing that one time, you might have thousands of people seeing that over 10 years. So because it re-victimizes the victim as it's spread through the internet, the person, meaning the defendant, will get a greater penalty.
What legal challenges could arise in proving these charges beyond a reasonable doubt?
Well, the first thing that the prosecutor has to do is establish what's called foundation, to show that, in fact, these images were found on the defendant's devices and were obtained by the defendant. And how do you do that? Well, it's easier than what you think. We all have and we all know about what's called IP addresses, Internet Protocol. So when we have a device, say we have our smartphone, and we're walking through a say a Starbucks coffee shop in New York, well, you're going to use the IP address at that time. And if you download something that's illegal, well, certainly they're going to be able to see that this IP address was affiliated with that coffee shop and specifically your cell phone, and it was downloaded at that time. Now, of course, you could always have the defense, well, I didn't have my cell phone at that time. Somebody else had it. Of course, you could have that defense. But that's a defense. It doesn't mean you can't face those charges. So that's what investigations and prosecutors do. They connect the dots. They show that the image through different types of addresses on the computer was downloaded, manipulated, something was done with it by the defendant.
Now, we just talked about the amount of charges, right? Could the number of charges result in a plea deal, or does the severity of the case make that unlikely?
I would imagine this case will be pled out. I mean, there's just too much at stake for the defendant. I would think that the only way a case like this would go to trial is if the prosecutor simply says, there is no plea bargain. So if you want to plead guilty, you'll have to plead to everything. And that's unlikely because in our system, no matter what state you're in or the federal government, most of the time judges want to see cases resolved. And it's the right thing to do because if every case went to trial, well, our system would grind to a halt. You want to encourage that people negotiate and try to resolve their matters. So I would think in a case like this, yes, it's going to have some type of resolution before trial.
Now, law enforcement reportedly went through hundreds of records. I know we touched a little bit on IP addresses and things like that, but what kind of digital forensic work goes into prosecuting online crimes? Because it's a lot.
It is a lot, and it's a lot of homework for the investigator. But it's basically comes down to this: the investigator or law enforcement will get some type of tip. It could be from the exploited and missing children's group out of Washington, D.C. It could be from some local person who says, gee, I saw this image on Bill's computer or his smartphone, something like that. And then they go from there. And usually the next step is some type of a search warrant because a police officer, investigator simply can't say, hey, Verizon, T-Mobile, whatever it is, we want to search John Doe's phone. You can't do that. So you go to a judge and you get a search warrant saying, look, here's what we need to look at, judge. And if the judge signs it, well, then you're off to the races. You could get in there. You could see what this person has been Googling, what type of images have been downloaded. And then you can further see if the person has been sharing the images. Because it's not only a crime simply to have such an image, it's also, in most situations, a crime to disseminate, meaning to spread those images around.
And I guess, listening to all of this, it makes it hard for a person to say, oh, well, it's not mine, or, oh, I didn't put it there. How does law enforcement verify, though? Can you break that down, verify the authenticity of digital evidence in these types of cases?
Yes, there's basically two things that law enforcement will try to, dispense with. One is if the suspect's computer system, cell phone, whatever it is, was hacked, meaning that some nefarious group or person, grabbed their IP address and started doing things with it, whether it's to download child pornography or use it as, say, some type of identity theft and set up credit accounts, something along those lines. So law enforcement will try to determine if the suspect's computer system was hacked and say it wasn't. Okay, well, they've checked off that box. The next thing they'll try to do is show proximity or possession of the device. So what does that mean? That means that they're going to try to gather evidence that, in fact, the suspect was with his cell phone when the items were downloaded. So say, for instance, the suspect, was, I don't know, maybe going through a surgical procedure and his cell phone was at home. That's going to be great evidence for the defense that, in fact, he wasn't the one who downloaded it. So the investigators will try to dispense with those two things to see if it was hacked and to see if whether or not the suspect was near or had possession of his phone at the time the crime was committed.
Now, in cases involving explicit images, how do prosecutors ensure that minors are not further exploited during legal proceedings?
Well, it's something that's very important to do, which means that if there really is going to be a trial and you have these images that will be displayed to the jury, and you will have to display them as a prosecutor, you want to make sure that courtroom is locked tight, which means that whoever is seeing those images cannot disseminate them, cannot reproduce them. They're not available to the public. I mean, say you're in a state, and most states allow this, where cameras are in the courtroom. Obviously not New York and not in the federal system, but in most states, cameras are allowed. Well, of course, those images are going to be blacked out for the public to see. And, you know, when you deal with cases like child pornography, even in terms of the prosecution and the defense going over evidence, it is highly regulated. A prosecutor can't simply say, hey, defense attorney, here are the images of child pornography we want to produce at the trial. It just doesn't work that way. These are tightly controlled systems, as they should be, because what you're dealing with is you're dealing with children who are victimized in those images. And again, you don't want to have those kids re-victimized every time someone else is looking at the image.
What legal strategies might his defense team use to counter the prosecution's case?
Basically, he's only got two defenses. One is somebody hacked my system. But, you know, if there's no evidence of that, it's going to be hard to pull off. Second is that he didn't possess the items when they were downloaded, meaning that somebody else must have downloaded them or they got on his phone somehow. Again, like the example, if he was, having some type of medical procedure, or he was, perhaps maybe a suspect is in the physical labor industries. He's working outside. He's busy 10 hours a day and his cell phone is in the pickup truck or it's in some other location. He just doesn't use the phone while he's working. So that's how you would try to do it. I would suspect, though, in this case, the defense is probably going to try to work something out with the prosecutor before trial.
Well, given the volume of the charges, what kind of sentence could Harry be facing if convicted?
Well, I'm not licensed in Louisiana, but I would imagine it's decades. In most states, including and also in the federal system, child pornography is a serious offense. In the federal system, it's not an issue as to whether you go into prison. It's a matter of how long. In some states, like here in Minnesota, on your first offense, normally there's not a prison sentence. They will allow you to do some type of probation. But again, every case is different. And the more images you have, the greater penalty you're going to face.
Now, if new victims come forward, how would that impact the case? Would that mean potentially a plea deal could be tossed out, or it'll just be more charges piled on?
Usually, when you're in these types of cases, your plea deal will include this, that right now you're going to get X, Y, and Z sentence, regardless of any new information that comes out. Because it really wouldn't make sense for a defendant to say, sure, I'll accept 10 years. And then a month later, after they're going through more information, they find more images. You basically would try to get an agreement that says, on this whole matter, here's what we're going to agree to, regardless of what pans out from now till sentencing.
Could the suspect face federal charges, or is this strictly a state-level case?
Anytime you're dealing with child pornography through the internet or any type of computer devices, you're in federal jurisdiction as well as state. So the feds could step in. Now, normally they don't. 95% of all criminal charges and cases are state cases. The feds only get involved in a select few. But, it's up to the U.S. Attorney's Office in Louisiana as to whether or not they would take this case. But normally the states prosecute these types of cases.
And just explain for those that don't know, is it possible for the state to charge him and for him to get federal charges, or it'll just be either or?
It is possible for both jurisdictions to charge, and here's why. We operate in a system called a dual sovereignty, which means a dual government. There are state laws, and below them, there are county and municipal laws, but there are state laws, that's one jurisdiction. And then there are federal laws, that's a separate jurisdiction. So you could be convicted in state court for child pornography, and then the federal government come along and charge you also for the same type of child pornography, and you get a federal conviction. That's legal, but it just doesn't happen too often. Normally, just one jurisdiction does it. So for example, because the federal government has more onerous, more strict types of sentencing, and they're more powerful, and federal law usurps state law. Normally, if the feds step in on a state case, the state will simply dismiss their case or step aside and let the federal government prosecute first.
If convicted, what kind of parole restrictions could he face upon release?
Most of the time, in most states, a person would be under supervision for the rest of their life when they have so many charges dealing with this kind of nature of crime. So, that means that they would have to register as an offender for life. They could be on different types of monitoring. In many states, they use GPS, global positioning systems, some type of ankle bracelet to know where a person is. In other states, there are things like you have to check in with parole officers. You have geographic restrictions, meaning that you can't go next to, say, elementary schools or things like that. And many times there are restrictions on your own contact with other people, such as you're not allowed to contact juveniles unless there's an adult supervisor there with them.
Is there a chance of civil lawsuits because of this from victims and their families against the suspect or even the school?
Definitely against the suspect, because anytime you have someone who's alleged to have committed a crime and say they're convicted, sure, you could have a civil case against them. Against the school, it would depend. And that would depend on whether or not, like in a general way, the school knew about it, they didn't do anything about it, their rules on engaging, a teacher engaging in certain conduct with a student, their rules are lax, their supervision is lax. It would really depend on the negligence of the school. I think of a lot of these types of internet crimes also should be looked at under what's called the Communication Decency Act, Section 203, which specifically gives immunity to internet providers. You see, if all of a sudden a newspaper would allow some reader to publish this type of criminality, you could sue the newspaper. But under federal law, Section 203, with the Communications Decency Act of 1996, that amendment was done then, internet providers are immune. So, really, Congress should step in and change the law, because if you have a provider that's not monitoring who's going on their systems, who's, putting images out there, really, Congress does have the authority to put some of the responsibility on the internet provider to police these sites.
Yeah, you definitely bring up a good point there. And this is a case that we will be following along very closely. Thank you so much, Joe, for coming on.
Thank you for having me.
Jarvis Harris' bond is set at $150,000. And this isn't the first time we've reported on teachers getting arrested. Earlier this year, we reported on an elementary school principal and a third grade teacher in Florida who are facing criminal charges for allegedly throwing a white lie party where more than 100 kids ages 13 to 17, including one that got a DUI, were caught drinking alcohol and wearing t-shirts with a, quote, white lie written on them, according to police. In Wisconsin, an engaged elementary school teacher was arrested for a child sexual assault charge after letters in her backpack allegedly revealed that she had told an 11-year-old student, quote, "I do love you more than anyone in this world." In this case, the victim's parents learned their son and the suspect were allegedly talking on the phone after school, leading them to confiscate his phone and report the evidence of sexual abuse they found. In Texas, a high school cosmetology teacher and her son were arrested for human trafficking charges after they allegedly recruited troubled teens into prostitution. According to the criminal complaint, the teacher reportedly offered reported runaways a place to stay at a hotel she paid for where they would engage in prostitution. Back in Florida, a youth pastor and teacher was arrested after he allegedly used his church's Wi-Fi to download massive amounts of child sexual abuse images. According to detectives, 54,000 images were discovered on accounts and devices associated with the sixth grade teacher. And who could forget this story out of New Jersey? An elementary school teacher was arrested after reportedly sexually abusing one of her former students for 4 years and later gave birth to the boy's child. For Law and Crime News, I'm Kennedi Walker.